Get ready for a legal dictation. 5 seconds. Start. Insofar as the present respondent Deputy Commissioner is an officer under Section 3 of the Act, Section 6 of the Act has no application. Full stop. Only with respect to officers appointed under the Central Act, the exercise of jurisdiction would be circumscribed by a notification that would have to be first issued by the state government, before such jurisdiction may be created in their favor. Full stop. Upon clear language of the provisions of the Act, the officers appointed under the Act would continue to be governed by the provisions of Sections 3 and 4. Read with Section 2 (91) of the Act and the general orders issued by the Commissioner in that regard, issued with reference to the power exercised under Section 5 of the Act. Full stop. Paragraph change. Hence, the decision relied upon by learned counsel for the petitioner are found to be wholly distinguishable. Full stop. In Commissioner of Customs versus Sayyid Ali and others (supra), two conflicting orders of the tribunal existed. Full stop. In the first set, the Customs, Excise and Gold (control) appellate tribunal had reasoned, the Commissioner of Customs (preventive), Mumbai was not a proper officer under Section 2 (34) of the Customs Act, 1962. Full stop. In the second set, a contrary view had been expressed by the Central Excise and Service Tax Appellate Tribunal. Full stop. Both sets of orders of the tribunal came to be examined by the Supreme Court in that decision. Full stop. Dealing with the same, and after taking notice of the provision of Section 28 of the Customs Act, 1962, hereinafter referred to as the Customs Act, the definition of proper officer given under Section 2 (34) of the Customs Act, and, after taking note of the fact that the Collector of Customs (preventive) had not been assigned any function under Section 28 of the Act, it was held, the adjudication order passed by the Collector of Customs (preventive) lacked inherent jurisdiction. Full stop. Paragraph change. Relevant to our decision, in paragraphs 20, 21 and 24 of the report, it was held as under paragraph change. From a conjoint reading of Sections 2 (34) and 28 of the Act, it is manifest that only such a customs officer who has been assigned the specific functions of assessment and reassessment of duty in the jurisdictional area where the import concerned has been affected, by either the board or the Commissioner of Customs, in terms of Section 2 (34) of the Act, is competent to issue notice under Section 28 of the Act, any other reading of Section 28 would render the provisions of Section 2 (34) of the Act odious, in as much as the test contemplated under Section 2 (34) of the Act is that of specific conferment of such functions. Full stop. Paragraph change. Moreover, if the revenues contention that once territorial jurisdiction is conferred, the Collector of Customs (preventive) becomes a proper officer in terms of Section 28 of the Act is accepted, it would lead to a situation of utter chaos and confusion, as much as all officers of customs in a particular area, be it under the Collectorate of Customs (imports) or the preventive collectorate, would be proper officer. Full stop.